Well, good afternoon. We convene this hearing of the Subcommittee on Oversight and Investigation to gain a better understanding of the impact abusive patent assertion practices are having on businesses, jobs, and the economy. Back in August of 1787, when James Madison was drafting the Constitution, he and Charles Pinckney offered amendments dealing with copyrights and premiums for the advancement of useful knowledge and discoveries. In September of 1787, the wording included in the Constitution in Article 1, Section 8, Clause 8, discussed the powers to secure for unlimited times to inventors the exclusive rights to their discoveries. This is the basis of U.S. patent law, and patents and trademarks are covered in the Commerce Clause, which makes this issue a defined jurisdiction of the Energy and Commerce Committee. Now, let me state at the outset that a strong and fair patent system is essential to an innovative marketplace. Inventors and companies should be encouraged to research and develop ideas, technologies, and products and be rewarded for their risk and investment. In addition, I fully recognize that patent rights are only as valuable as the holder's ability to enforce them. The intent of today's hearing is not to assess the current state of our nation's patent system or to opine on the various legislative proposals that have recently been introduced or discussed in this area. Nor is this hearing intended to be a comprehensive look at all the patent assertion activities that occur in advance of litigation. This is about gathering facts about the nature and scope of this problem. Our purpose in holding this hearing is to learn more about a number of questionable practices that have recently proliferated and the significant direct and indirect costs they have imposed on businesses large and small. Specifically, most of the witnesses testifying today are representatives of companies from different industries who have received letters from various entities demanding licensing fees or threatening litigation over the purported use of patented technologies or products. Frequently, they are little more than form letters blasted off to hundreds or even thousands of recipients, with the hope that some of them will quickly cave in order to avoid the prospect of expensive litigation. It has been estimated that the average patent trial can last over a year and cost upwards of $6 million. This is simply not a viable course of action for a small business, and unfortunately, this makes them attractive targets. We will hear today about some of the more egregious types of demand letters and whether they even contain sufficient information to allow for an informed response. Most importantly, we will hear about how responding to such demanding letters impact a business's ability to attract new capital, utilize new technologies, hire new workers, and ultimately grow their company and our overall economy. One recent study from researchers at Boston University calculated that patent assertion activity directly cost defendants and licensees $29 billion in 2011. This figure represents a 400% increase since 2005 and does not even include the indirect costs to businesses such as diversion of resources, delays in new products, and loss of market share. A number of other studies on patent assertion, entitled PAEs, have recently been conducted. We'll hear from a number of individuals with significant experience in this area about how such practices have evolved, whether more egregious tactics are currently being employed, and if so, what can be done to stop them without weakening legitimate intellectual property rights, enforcement activities, and pre-litigation communications. Further, the Federal Trade Commission announced in September that it will be conducting a formal inquiry examining the businesses' practices of patent assertion entities in order to expand the empirical picture on the costs and benefits of PAE activity. We look forward to reviewing the results of this inquiry, and in the meantime, we'll continue to further our understanding of such practices. As always, we will follow the facts so that our oversight can inform any solutions that may be proposed to address the underlying problems relating to abusive demand letters and related practices. Today is a first step in that process. I look forward to hearing the examples and perspectives provided by our witnesses, and I look forward to hearing from those who may disagree with them in the near future. I fully anticipate that we can work together on a bipartisan basis on these issues going forward. With that, I recognize Ranking Member of this subcommittee, Diana DeGette, for opening statement, and I know she has a high level of interest in this issue.
Thank you very much, Mr. Chairman, and I do believe we can work together on a bipartisan basis on this because it's a real concern. It's a concern that's been increasing a lot. Several people have bills that they're planning to introduce, and I think this will give us some good facts as we look towards writing legislation. In the past few years, a number of companies have emerged and their sole business model is to assert overly broad patent rights and use the threat of litigation to extort settlements. This is an abuse of the patent process, which, as the chairman accurately said, is a very important process. But recently, we've seen the abuses getting worse and worse as these actors are targeting not just large corporations, but also small businesses who are just using everyday technology like office scanners or wireless routers. The small businesses, nonprofits, and startups using these technologies lack the expertise and resources to litigate the questionable infringement claims, and frankly, they're being singled out because they can't afford to defend themselves. And so what they end up doing is paying money so they can return to focusing on their business. Now, clearly, this is not acceptable. It's extortion, plain and simple. And it results in significant harm to inventors, small businesses, and startups. It costs the economy over $80 billion a year. And you know, I agree, the U.S. patent system is an incredible tool for innovation and economic growth. In theory, legitimate patent assertion entities could protect small inventors by enforcing their rights if, in fact, those rights are legitimate against more powerful companies. But in practice, some of these firms transfer only a small amount of settlements or fines back to technology inventors and producers. They've purchased these patents or acquired them in some way, and then they're asserting the rights over people who can't afford to defend themselves. And that's why we have the name patent troll, because of these predatory tactics. One notorious patent troll, Innovato, sent over 13,000 demand letters to users of Wi-Fi routers. Small businesses have received intimidating and harassing letters demanding costly settlements or licensing fees. Too many of these mom-and-pop establishments pay hefty settlement fees just to avoid protracted multi-million-dollar patent litigation. Last week, Nebraska's Attorney General testified in the Senate about an elderly gentleman, Mr. Eldon Steinbrink, who received a demand letter from MPHJ Technologies alleging infringing use of a scan-to-email patent through his work for Phelps County Emergency Management. Well, in fact, Mr. Steinbrink never worked for the county. He once served on the county board many years ago, and now he lives in a nursing home. Patent trolls like MPHJ fail to do even basic due diligence about their targets, and I think that's because, frankly, they just don't care. They hope somebody will pay the money. So I think it's important that we find the right balance with patents, but I think we can all agree that these end users should not be targeted at all by patent trolls, and the abusive and harassing practices have got to stop. And so, you know, I think there's a lot we can do. The demand letters should be transparent. They should contain meaningful information. My colleague Jared Polis is looking at legislation that has more registration of people who are sending these letters out. There's a lot going on. And I think because of this committee's history of protecting consumers and small businesses, this is the perfect place. So I want to thank our witnesses. This is going to be a good hearing, and I want to yield my last minute to Mr. Welch, if he'd like to have it. Oh, do you want 5 minutes? Okay, then I'll yield back, and he'll just take our other 5 minutes.
Thank you.
I don't think we have anybody else on our side with an opening statement, and recognize we're going to vote soon if you want to take the
Well,
next one.
I do
Recognize
appreciate it.
Mr.
Just a minute, Mr. Chairman. I appreciate the hearing. This is an unbelievable ripoff, obviously, and it's incredibly detrimental to large businesses and to small nonprofits. And my concern is because in Vermont, we've just been getting hammered. My Web Grocer, which is a startup company doing really well, has 180 employers. They've had 6 patent troll attacks. And it's resulted in that company not being able to hire 8 to 10 people. Then at the other end, we've got a small nonprofit where they provide help for disabled kids, and it's a hand-to-mouth operation. They're raising money from folks in the local community, doing work that's incredibly important to those kids and to the parents. They got attacked by patent trolls. They're in no position to do it. They open up the mail, and it's a demand letter, all formal, all threatening, all this is the end of the world. And it creates enormous emotional anxiety as well as financial peril. And there's been it's such a small community in Vermont where it's not just the big business and the small business. There's a real ripple effect in the community that the Attorney General in the state has taken a lead in bringing the first in the nation lawsuit against the patent troll MPHJ technologies based on our consumer protection laws. And the state itself, under Governor Shumlin, has passed a bill that makes it a civil offense if there are bad faith assertions of patent infringement and allows victims to see actual and punitive damages. So we're trying to act as a state, but this clearly is something that requires a national attention. So I am so grateful to each of you to be here today to help Congress get focused, and you've got a bipartisan buy-in here in the halls of Congress. So we've got a chance to break the mold and actually get something that needs to be done, and with your help we'll succeed. Thank you. I yield back.
Gentleman yields back. Just for the members here, we know we're going to have votes probably about 20 of or quarter of the hour. So we believe during that time, between now and then, we can get through all of your testimony and then try and start some questions. Immediately after votes, we'll reconvene and be able to continue on with other questions. So I'd now like to introduce the witnesses for today's hearing. Quite a distinguished panel. Our first witness is Robin Feldman, the Director of the Institute for Innovation Law at the University of California's Hastings College of Law. She has written extensively on patent assertion practices and how they've changed over time. Our second witness is Charles Dwan. He is the Director of the Patent Reform Project at Public Knowledge. Public Knowledge is dedicated to promoting technological innovation, protecting the rights of all users in technology, and ensuring technology law serves the public interest. Our third witness is Lee Chang. He is the Chief Legal Officer at Newegg, Inc. Newegg is a global internet retailer that is the largest privately held e-commerce company in North America. Our fourth witness is Daniel Siegel. He is the co-founder and director of business operations at FindTheBest.com. Find the Best is an online research engine that equips people with information and tools to make informed consumer decisions. I felt like I just did a commercial there, man.
You did.
And act now, and you get one more free. Next, we have Justin Bregel. He is a general counsel for the Texas Hotel and Lodging Association. He manages and oversees a legal program servicing over 2,500 association members. He serves as the primary legal counsel to over 10 local lodging associations across Texas. Our last witness is Jamie Richardson. He is the Vice President of Government and Shareholder Relations for White Castle Restaurants. I'll now swear in the witnesses. And now you are all aware that the committee is holding an investigative hearing, and when doing so has a practice of taking testimony under oath. Do you have any objections to testifying under oath? None of the witnesses have objected to that. So the chair then advises you that under the rules of the House and the rules of the committee, you are entitled to be advised by counsel. Do any of you desire to be advised by counsel during your testimony today? None of the witnesses have said they want to be advised by counsel. In that case, if you'd all please rise and raise your right hand, I'll swear you in. Do you swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, thank you. All answered in the affirmative. You now are under oath and subject to the penalties set forth in Title 18, Section 1001 of the United States Code. You may now begin a 5-minute summary of your written statement. Begin with Ms. Feldman. Welcome. You have 5 minutes.
Mr. Chairman, esteemed members of the committee, I am honored to be here today. As an academic, I have studied patent assertion behavior both in the litigation context and in the pre-litigation context. And in recent years, a new business model of patent demands has exploded on the scene. It preys on people's fears of the costs and risks of litigation, and it takes place largely outside the courthouse with no judge, jury, or regulator in sight. Much of the time, it is shrouded in non-disclosure agreements, so no one is allowed to talk afterwards. The behavior is based on the following. There are millions of patents outstanding, and it is very difficult to know what any patent covers. It will cost about $1 million to $6 million in litigation expenses to find out. And if you take the litigation route, there's a risk. If you lose, you could be subject to massive penalties for damages, and you could also have your product shut down. So with that leverage, here is a sample of some of the modern techniques that have appeared. First is what one could call the peddler's bag. Suppose you are a computer manufacturer, and I claim that your manufacturing process infringes my gumball patent. Now, you may think that's pretty far-fetched, but suppose that I threaten to throw 50 more patents at you as well. You may be tempted to fight off the first, but you may not have the stomach or the litigation budget to fight off all 50 of them. The costs of investigating 50 patents is substantial. Also, the risks of litigation. Maybe not the gumball patent, but maybe something in there will stick, so perhaps it's better just to pay a license fee. Another behavior is what I call the assault rifle technique. With this approach, patent assertion entities target a vast number of people, hoping to obtain moderate settlement amounts from as many of them as possible. For example, patent assertion entities have targeted small businesses for using scanner equipment that they have purchased and coffee shops for using Wi-Fi equipment. Those who receive the letters know nothing about the patents that are involved and have no idea how to respond to these demands. Still, another behavior is known as privateering. If I'm a product company and I launch my products against a competitor, ordinarily that competitor will launch its products back at me and put my products at risk, so I might not bother. But in this new world of entities that don't make any products, I have many options. I can transfer some of my patents to an assertion entity that could target my competitors. I can even structure the transfer so that I share in the returns. In that way, I damage my rivals, I get a return on some of my patents, and my hands are clean. These three are samples of the techniques that are being utilized. And as with many pressure sales techniques, the demand letters may say things like, the settlement costs will go up if you consult a lawyer, if you ask for more information, if you wait until a lawsuit is filed, or if you wait until others accept the offer. Some demand letters require that the company sign a broad non-disclosure agreement even to get basic information. And this leads me to one of the many troubling aspects of this behavior, which is that much of it is shrouded in non-disclosure agreements and hidden behind layers of shell companies. This makes it very difficult for regulators to see bad behavior when it is occurring. It's also difficult to hold anyone accountable because the shells may have no meaningful assets at the end of the day. Now, the impact of these patent demands on companies large and small is troubling. A recent study of mine showed that 1 in 3 startup companies has received patent demands, and that most of these are coming from assertion entities that don't make any products. Other scholars have estimated that very little of the vast amount of money changing hands ever gets back to the inventors who actually filed for the patents. And really, it does not take fancy economics to know that time spent analyzing patent demands is time away from innovating. And money spent on patent demands is money not spent hiring workers. In closing, I do want to stress one important issue. Patents are essential for innovation in this country, and patent rights are useless if they cannot be enforced. I'm not talking about the legitimate protection of an invention. I'm talking about shadow games that prey on people's fears and that exploit the system. I have submitted several pieces of my research as my full testimony for the record, and I look forward to answering any questions. Thank you.
Thank you for staying both under the time limit. I'm impressed that you've memorized most of your document. Thank you so much. Mr. Dwan, you're recognized for 5 minutes.
Thank you, Chairman. Mr. Chairman Murphy, sorry, is this on? Yes. Mr. Chairman Murphy, Ranking Member DeGette, and members of the subcommittee, thank you for inviting me to testify today on this important issue. My name is Charles Dwan, and I am the director of the Patent Reform Project at Public Knowledge. As a bit of background, Public Knowledge is a nonprofit organization dedicated to ensuring that technology law serves the public interest. Prior to working at Public Knowledge, I served as a patent attorney where I both obtained patents and defended against demand letters. I also have worked as a Silicon Valley software developer, and these experiences, along with my conversations with various stakeholders, inform my views on the patent system. We're here today to discuss the role of patents in our innovation economy, and it's worth beginning from the beginning, I think. The principle behind the patent system is an exchange. Patents are granted to encourage inventors to contribute their inventions to the public. Our patent system ultimately must serve the public interest. And in many areas of our patent system, it does indeed work this way. But far too often, scheming speculators and clever lawyers find ways to abuse patents and profit off of the system while detracting from the social good. The most egregious among these abusers include patent assertion entities and so-called patent trolls. Instead of innovating and creating jobs for Americans, patent trolls manipulate the small businesses and individuals who actually innovate and create these jobs, extorting unjustified fees through nuisance threats of litigation. One of the ways they succeed in doing so is through the sending of demand letters. These letters assert that the recipient infringes a patent and then demand a settlement or a license fee. Abusive demand letters exploit at least two problematic techniques. First, many demand letters are vague, misleading, and deceptive. They are threateningly intimidating and yet wholly uninformative, failing to explain what products infringe the patents, how they infringe, or even why. Some of the letters that I've seen fail to demonstrate even basic knowledge of the businesses of the recipients. MPHJ, for example, which we've talked about, merely alleges that, quote, a substantial majority. Okay. All right. Worse yet, some demand letters contain plain falsehoods and deceptions. I once represented this client who received a demand letter, and when we actually investigated the patent, we found that the patent had been invalidated in court. The sender simply bet that the targets would settle before those targets discovered that the patents were actually worthless. The sender could win that bet because of the second exploited technique, sending letters to small, unprepared businesses. Small businesses lack the resources, funding, and expertise to fight an expensive and complex patent lawsuit and are often forced to succumb to the letter's demands. This is especially true of non-technology businesses like the hotels, restaurants, and retailers represented by my colleagues. Just to give a sense of the price comparison, at the startup that I worked at, we ran our entire operation off of a couple $100,000 of angel investments. Now, $100,000 will buy you perhaps a single detailed analysis of an asserted patent by a lawyer like myself. The full lawsuit will cost in the millions. This is an unfair situation that must be addressed. These abuses take advantage of two asymmetries of information. First, demand letter recipients lack information to react on an informed basis. Second, researchers and regulators lack information about the shrouded world of demand letters and the abuses therein. I'll present solutions for both. The first solution I call demand letter transparency. Senders of demand letters in appropriate situations should be required to disclose relevant details of their campaigns. Those disclosed details should be aggregated into a searchable database accessible to individuals, businesses, researchers, and regulators. All of these parties stand to benefit from demand letter transparency. The only parties who stand to lose are abusers of the patent system. The second solution I call truth in demand letters. Congress has repeatedly dealt with misleading advertisements, loan offers, and other solicitations by requiring solicitors to prominently disclose truthful, relevant information in the text of the message. A patent demand letter is no different. It is an uninvited solicitation to purchase an intangible product, namely a patent license, and it should be regulated as such. Senders ought to be required to disclose truthful, relevant information in their demands. These are straightforward reforms that would minimally burden legitimate patent owners, provide fair notice to small business, aid regulators in crafting good policy, and prevent abusive practices that ultimately detriment the public interest in promoting innovation. I urge Congress to consider them closely. I thank the committee for taking on this important and timely topic. Thank you for inviting me to testify, and I look forward to your questions.
Thank you. I also appreciate you staying within the time as well. Mr. Chang, you're recognized for 5 minutes.
Thank you, Mr. Chairman and members of the subcommittee. Thank you, Mr. Chairman and members of the subcommittee. Patent trolling is a growing and uniquely American problem caused by loopholes in patent law that were estimated to cost the American economy over $80 billion in 2011 and probably a lot more today. American businesses and consumers who ultimately pay higher costs for everything because of patent trolling need relief from Congress, and soon. I am the Chief Legal Officer of Newegg.com, an internet retailer. We are members of the Consumer Electronics Association, which represents the interests of over 2,000 members of the innovation industry. We deeply appreciate patents and innovation. Newegg is a uniquely American success story founded by 4 immigrants in 2000 on a shoestring budget to sell electronics products online. We're now the second largest online-only retailer after Amazon. We employ almost 1,000 Americans. We have always been profitable in a notoriously low-margin business and achieve profitability largely by keeping our costs down. I work in a cube in a warehouse. We serve Folgers in our office, and everywhere I go, I fly coach. Upon joining Newegg in 2005, I was very surprised to get a number of demand letters asserting that we infringed someone's patents because we don't really make anything. We're a retailer, buying products from innovative companies and selling them to end-user consumers. The demand letters were generally vague, and the patents asserted against us cover common and obvious functionalities used in every single e-commerce website, like the shopping cart or search boxes. In one instance, a patent troll sent us a demand letter claiming we infringed 6 of their patents. After being told that our patent counsel said we didn't infringe on any valid patent claims, the troll told us that they had thousands of patents, that we likely infringed something, and to just pay up. Many, if not most, demand letters declare that the troll is the owner either of patents or patent portfolios without much of any analysis as to why the alleged infringer actually infringes. They allude to the high cost of litigation and suggest that it makes sense to resolve the issue early by having the infringer pay money to take a license. These letters may reference other companies who have taken such forced licenses to add credibility to the demand, and for a small company that gets such a letter, excuse me, the only practical path is to pay up and serially. Patent trolls and their contingency fee lawyers view small companies as sheep to be sheared every couple of months, and these demand letters can be crippling to a startup company. In Newegg's case, the trolls who hit us offered to settle for initially high 6 figures to low 7 figures, and all of our co-defendants in the early cases settled, sometimes for millions of dollars. Not being a seasoned patent litigator or a patent attorney, I wasn't smart enough to not ask them basic questions like, why do we have to pay millions of dollars for utter crap? And soon realized that patent trolling was a complete scam like securities class action litigation. Settling with trolls to avoid the cost and inconvenience of litigation might save a little bit of money up front, but would encourage more and more lawsuits. Settling would simply feed the beast. Since Newegg's profit margins are low, we simply could not afford to serially cut settlement checks. We also couldn't spend what our competitors spent on legal defense. We needed another path. I spent a lot of time and effort on ways to lower defense costs without compromising quality. I was very nervous when the jury for a shopping cart case in Texas came out of deliberations and they could have awarded the troll $34 million. They didn't, and on appeal we invalidated all of their patents. Despite being sued or threatened over 30 times in 8 years, Newegg has never lost a patent suit after appeal. And not surprisingly, smart trolls don't sue us anymore. Unfortunately, we're the exception to the rule. Small companies and startups don't have the resources to fight. Large companies settle because it's cheaper to do so. The overwhelming majority of patent troll suits settle even when the asserted patents are terrible quality or when a defendant likely does not infringe because of the high cost of defense. Although our strategy of resisting frivolous lawsuits appears to be working, we remain committed to helping reform patent law. We stay in the fight because not long ago, we were a small company could not possibly have launched if our programmers had to look over their shoulders and pay millions of dollars every single time they wrote a line of code. Moreover, it's just the right thing to do. Patents are legal monopolies granted under a visionary piece of legislation to spur innovation to benefit society. The Patent Act was not passed to reward extortionists who are taking advantage of loopholes in patent laws to force honest, hardworking business people and entrepreneurs to pay premiums to avoid the cost of litigation. It was passed to benefit society. Those who abuse patents do not deserve windfall profits. Congress must step in. Common sense steps can be taken to increase the cost of abusively asserting patents and to allow small companies and startups to innovate and operate without fear. Provisions included in H.R. 3309, the Innovation Act, and also heightened requirements for demand letters would be a great start. Thank you again for the opportunity to testify.
Thank you. Just made it. We're going to try and get through a couple more before we have to run to the floor and vote. Mr. Segal.
Chairman Murphy, Ranking Member DeGette, and members of the subcommittee, thank you very much for this opportunity to testify in front of you on this pivotal issue of the abuse of the patent system and demand letter reform. I am Danny Segal, Director of Operations at Find the Best, a research platform that helps 20 million consumers and businesses each month get the information they need to make an informed decision on a variety of topics. In the last 6 months, we have unfortunately received 2 demand letters. The first was from the shell company LumenView. It is a 5-page document, as you can see here. You would think in these 5 pages they could provide some details into how we actually infringe on their said patent. But aside from naming the patent and naming the feature that infringes, there are no specifics. The rest of the 5 pages are simply spent using threats to scare us into settlement. These threats include full motion litigation that they are prepared if we defend ourselves, protracted discovery process, and settlement escalations if we defend ourselves. In other words, if you try to defend yourselves, they will make it an expensive and time-consuming process for us. The correct business decision for us would have been to accept their one-day special offer of $50,000. and have this issue go away. However, that is just blatant extortion. We were even told that by the plaintiff that this was the correct business decision, and our investors and board members would have preferred we did this as well. However, our CEO, Kevin O'Connor, took a different stance. He decided to do what was right and personally finance litigation to prove that we were innocent and to call out the scam that was going on. Yesterday morning, the judge on the case denied the protective motion for the gag order that they filed against us. They wanted to silence us so that we could not share this story with you today. The second demand letter we received was a four-sentence demand letter, as you can see here, all of 4 sentences. It simply states we infringe on their auto-scrolling technology, names 3 possible patents, and then gives a link to our homepage as evidence of infringement. These 3 patents have 78 claims. That is a lot of claims for a small company like ourselves to go through and figure out if we actually infringe or not. Without inside counsel and scarce resources, it takes a lot of time and effort for us to go and decide what the best course of action is. Additionally, they send this letter certified mail, so we could be in violation of willful infringement if we do not actually do our proper research. We had to hire an outside counsel to spend several $1,000s investigating this to write a letter of reply. In our letter of reply, we asked for specifics because we can't figure out how we actually infringe. These vague tactics are all too common in these demand letters. I wish I could say that our story was unique, but it's not. The only unique thing about our story is our public stance. We have heard from hundreds of people with similar situations like us that wish they had a voice, that wish they could talk out about this, but they've been coerced into signing NDAs in order to settle, and their voice has been silenced. I'm here today to represent them as well. Comprehensive patent litigation reform is necessary, and demand letter reform is essential. Proper disclosure guidelines would greatly help companies like Find the Best understand how we actually infringe, which claims we actually infringe on, and provide details so we can actually research this in a matter to resolve the issue. The FTC should also look into investigating several of these unfair and corrupt practices. It is very blatant that there's no good faith examples of how we actually infringe and of how we infringe. We did what was right. We fought this patent. We did not have to. In fact, taking the $50,000 settlement would have been the easy and less costly option. And I ask that you guys do what is right and stop this abuse of the patent system. Thank you.
Thank you. Mr. Bregel, you may take 5 minutes.
Thank you, Mr. Chairman and members of the committee. My name is Justin Bregel. I'm General Counsel at Texas Hotel and Lodging Association. Thank you for inviting me to testify today. We represent approximately 2,000 hotels across the great state of Texas, about 500 additional members on top of that. We've been in existence since 1903, and our mission is to advocate for and serve the Texas lodging industry. Our members work and live all across Texas, but one region in particular of the state has been plagued recently by a great deal of patent litigation activity, and this is for historical reasons. The Eastern District of Texas, known often as the Rocket Docket, sees and hears more cases related to patents per capita than any other jurisdiction in the United States. Our members sell a product we're all familiar with, hotel rooms, right? I represent the hotel industry. It's really simple. And so oftentimes I've been asked over the last couple days, why are you going to Washington to testify on a patent issue? What in the world does a hotel do that's related to patents? Our members, our operators don't understand patents. We don't file for patents when we build our lodging properties nor when we operate them. But our members have been given and served with not only demand letters, but actually lawsuits as well for failing to answer demand letters, simply for providing Wi-Fi in the hotels to guests. And we all understand that concept as well. Our guests expect and demand wireless technology. It's a part of this day and age and staying in a hotel. It's a very simple product that we offer, and yet we have been sued. Our members have been sued. Almost 100 hotels across the state of Texas were sued in the last 6 months or 9 months for allegedly infringing upon the Wi-Fi patent held by one particular patent troll. The letters start as a shakedown. pay us $5,000, a significantly smaller sum, but a sum that would be attractive for an independent lodging operator to seize upon to settle. Pay us $5,000 as a licensing fee, and we won't file suit against you. If our member, our hotelier, ignores that letter, they receive a lawsuit in the mail months later that alleges the hotel is continuing to infringe upon the patent holder's patent by providing Wi-Fi to hotel guests. And a suit like this, as we've heard, can cost upwards of $1 million to defend, $100,000 just to start the process with an IP attorney. And again, all our hotelier does is operate a hotel, right? We don't deal with patents. We have no way to know when we buy a wireless access point or a wireless router whether or not the manufacturer has provided all pertinent licensing on fees and patents to the patent holders. We don't know that. We're not in that business. We have no way of knowing which brands of equipment will be singled out. We have no way of identifying which one of our members will be targeted for a demand letter or a lawsuit. It's really incredible. So I get calls every day from hoteliers across the state of Texas with legal questions. They ask the most basic legal questions you can imagine oftentimes. And usually all of their questions are related to how can I avoid potential litigation? How can I avoid potential liability? I have no answer for my members on this issue, none at all. There's not a brand of Wi-Fi router or piece of equipment that I can tell them and assure them that they will not be sued for purchasing and operating. It's a real problem for us. So, we're here to ask for smart patent reform to look at this process. We need some protection for the end users here. We're not experts in the patent field. We're not. And, to be targeted like this it really is just a shakedown. Here for questions. Thank you so much for inviting me to testify.
Thank you. I think we can, do you have a full 5 minutes you need? Because we'll have to come back then and.
Okay, I'm going to go vote.
All right, I'll do it real quick then. Thank you. Go ahead.
Chairman and Ranking Member DeGette and esteemed members of the committee, thank you so much for the chance to testify on behalf of White Castle and the National Restaurant Association. For us, White Castle is a family-owned business, started in 1921 in Wichita, Kansas. Today we're based in Columbus, Ohio. But throughout our entire history, it's been a history of famous first. So we're big believers in intellectual property rights and understand the importance of this debate when it comes to patents. But for White Castle specifically, what we've been faced to deal with in the past year are 4 specific patent troll cases that we've had to face. And a lot of it has to do with how we connect with our customers. So we have lots of new technologies that we're trying to employ. For instance, the QR codes, the QR codes that will go on a package that make it easy to scan and to find out for a customer how to link to information. We got a letter about that asking that we refrain from using that further. We had a second one show up because we inserted a link into a customer email to once again make it easier for customers to get the information they crave, and received a letter on that. Most recently, we received a letter about having our White Castle logo appear on a White Castle map on our mobile app that we've created for our phone, with a firm claiming that they own the patent to place a logo on a map. And most discouraging of all is we're trying to be compliant with things like menu labeling that require that we soon post nutritional information on our menu boards. We've started to look at digital menu boards. Along the path towards employing digital menu boards, we didn't even get the benefit of a demand letter. We got a suit filed by one of the patent trolls, and that's what we're going to call them at White Castle because that's what they are to us. And in that suit, it claimed that we can't transfer information electronically to our digital menu boards, that's an infringement. Unfortunately for us, we're small. We're a medium-sized fast food chain. We're a family-owned business. We don't have the dollars to litigate. We've got 2 very gifted attorneys internally. They're awesome, but we have to rely on outside counsel when these patent cases come up to try to get the right guidance to understand where we can go with it. So what it's caused us to do, it's stopped us in our tracks when it comes to moving forward and talking to our customers. So the patent trolls are living under the bridge to tomorrow, and as we're trying to progress and move forward, they're slapping duct tape over our face and not allowing us to share with our customers what's really going on and providing the information that they want. So it's a real issue for us. We've chose not to pursue these technologies. We've had to set them on the shelf. We can't afford to get involved in some type of settlement who knows how high that's going to go, nor can we risk litigation because we're not going to bet the White Castle system and the 10,000 people who rely on us for their livelihoods and the communities that rely on us because some folks have decided that it's okay to not obey the law and just go outside of it on their own. So thank you for the chance to share.
Thank you. I appreciate you winding that up. We have 0 time left, so we have to run to the floor and vote real quick. I'll be back here within half an hour, so don't go too far away, and we'll be right back. Thank you. Thank you. We're reconvening this hearing of the Oversight Investigation hearing on patent assertion practices, and thank you for your patience, panelists, as we move forward this. Number of my colleagues are on the floor, in speeches, et cetera, we will go through, and perhaps I might ask if it is a matter that we may, we'll go through our questions back and forth, but if I have a couple extra questions on behalf of other members, I don't think we'll be going much more than probably a half an hour beyond.
That's fine, and you know, this committee has a history of allowing questions in writing. And Mr. Chairman, if you would agree to that, unfortunately, most of the rest of the Democrats probably won't be back because we have a Democratic caucus meeting right now. And I don't know what the Republicans have going, but I know that members of this subcommittee are very concerned about this issue. So if we could allow members to submit written questions, that would be wonderful.
Absolutely will. And so what I'll do is I'll take 5 minutes yourself, and then if sure. Go to our colleague there, and I may ask a couple other questions with unanimous consent. We'll proceed from there. See how nice we get along. This is an important issue to all of us. All right. Well, obviously, from the panelists here, I'll start myself with 5 minutes. You have similar perspectives on the impact of these demand letters that have had on your companies or in businesses in general. They're rather remarkable, the vagueness of them and the content and the impact they have. For those of you who have actually received demand letters, is this a recent phenomenon? You can speak to that. Who received those? Mr. Chang, you received one of those letters? Is this a recent issue?
Well, we've been getting them for about 8 years. So it depends on how what you define as recent, right? So it somewhat coincided with my arrival at Newegg, but I had nothing to do with it. So we crossed the $1 billion revenue mark right around that time. Historically, trolls, they just had such a wide field, easy pickings, that they would literally go down lists of the largest companies or the most successful companies. Getting your name as a fastest growing company in the Los Angeles Business Journal was going to make you that's what they based their demand letters on. And in recent years, as the trolling industry has demonstrated how lucrative trolling can be, more and more companies are getting demand letters. In some areas, the volume of demand letters is actually declining with larger trolls. They just go straight to litigation. because under the Medtronic, there's case law that states that a demand letter that is very detailed will give a prospective defendant the right to file declaratory judgment action in a venue not of the troll's choosing. So with larger defendants, sometimes the trolls will actually just go straight to litigation now. But for the smaller companies and startups, in all likelihood, their demand letter volume is increasing.
Ms. Feldman, why have these trends gone the way they have, with more of these taking place and with the kind of problems that have been described here today?
I think some very clever and very sophisticated people figured out how to game this system. Once that had happened, it was so lucrative that everyone became interested in jumping on the bandwagon. In the startup study that I mentioned, most of those who finance startup companies say that these demands have increased dramatically in the last 5 years against their portfolio companies.
Ms. Feldman, you're an attorney, correct?
I'm a professor.
Are there anybody here who's an attorney in this? Mr. Dewan, you're an attorney. Why hasn't the Bar Association brought up ethics concerns against those who just do this without information and just move forward?
Well, I think there are a number of concerns. Number one, as I think a number of the witnesses have alluded to, we often don't know who's behind a lot of these sorts of things. They hide behind shell companies. We don't know who's really behind a lot of the demand letters. So, it would be hard for the bar to go after them. Now, in terms of what the lawyers are sending out, they're sending out letters that are threatening. They're sending out letters that are uninformative, but they're not sending out letters that are illegal. Everything that they're saying is just communication, and there's nothing wrong with communication. The problem is that the underlying demands, which are being made not by the law firms themselves, but by the companies that are being represented by the law firms, those are the aspects that are problematic.
So what separates a good faith request or good faith letter from one that is a trolling one?
Well, I think it starts from the investigation that goes behind the letter. In my practice, if we thought that there was infringement of a legitimate patent, we would look at the products, we would identify what features of the products what features of the product infringed, why they infringed. We'd look carefully at the patents to make sure that everything was set, and then we would have the conversation. What I think we're seeing with a lot of these demand letters that are taking the shotgun approach that Professor Feldman talked about, we're not seeing this sort of investigation. I think I mentioned that MPHA has sent out letters that don't even talk about what the business itself does to infringe. They simply say that businesses like yours infringe, so therefore you should pay us a licensing fee. I think there are plenty of examples. If you take a look at some of the demand letters on EFF's Trolling Effects website, you'll see plenty of examples of letters that really evince no knowledge of what the company does, why they think the products infringe, what they think is wrong, and what they want the companies to do. And that is where the abuse comes in.
And real quickly, and then Ms. Feldman, a few seconds left. You testified that in recent years a new business model of patent demands has developed. Can you expand on what this old business model entailed, why it's changed, what impact this change has had on businesses and consumers?
Yeah, so traditionally, most patents didn't garner return. It's very difficult to translate a patent into an actual product. It normally takes lots of patents and lots of know-how to do that. The Patent Office has about 18 hours over a period of 2 years to look at patents, and these patents may have dozens of claims in them. So no one really worried that lots and lots of patents were being granted because the ones we cared about ended up in court. With a new business model, all of these patents, each individual one can be separated out and launched against companies. It's that particular business model that is wreaking havoc for companies across the country.
Thank you. I see I'm out of time, but I appreciate it. I now recognize Ms. DeGette for 5 minutes.
Well, following up on that, Ms. Feldman, and then what happens, so there's all these patents that were granted. The review of the patent examiners was minimal in many cases, so there's a lot of patents, and a lot of them are duplicative, right?
Yes, and also, a legitimate patent doesn't mean that you're launching it at an appropriate target.
Right.
You may have a valid patent, you're just sending it indiscriminately to lots of people.
And it doesn't mean that the people who you're targeting have in any way infringed against that patent, right?
That's right.
And most of these patents that we're talking about here are patents that have been obtained by these third parties. So it's not like it's the inventor who filed the patent application and had it granted. It's some third party, right?
It's true, although there is a new approach that appears to be happening, which is let's file patents and see if we can go after companies with these. The key question is, are there products being made, or are you just knocking on the door of existing companies asking for a handout?
Right. I was, when Mr. Dewan and Ms. Feldman, when you were answering that question, I was reading one of the letters that Mr. Chang was referring to, where it says, find the best is using automatic scrolling technology on their website, technology which we believe to be covered, and it's not, it doesn't even say specifically what that is, right?
It's actually
Oh, it was Mr.
Siegel's letter,
Siegel's?
but we've gotten
Sorry.
letters like that too.
Yeah. Sorry, Mr. Siegel.
Yes, when you get this letter and you're not a legal expert like me, you have to start investigating this. And there's 78 claims in those 3 patents. And if you notice, they don't mention which claims we can be
Right.
infringing on. So there's no due diligence on their part. There's no reason to believe they have a good faith reason to believe we infringe. They just take this template, insert company name, insert link to homepage, and send it out.
Yeah. Yeah. I mean, I can see that. Mr. Chairman, I don't know if these are in the record, but I'd like to put these 2 letters that Mr. Siegel had referred to in the record, because it is. It's frightening. And, you know, even if you are a legal expert, if you look at these, I'm sure you sent them along to your lawyer, and then the lawyer's having to, because I myself am a lawyer, and I used to represent companies before I came to Congress, and I had clients who got letters like this, and we had to comb through the patents, and it's even confusing to the lawyers. And, you know, this goes back, Mr. Chairman, to what you were asking about, why doesn't the Bar Association enforce this? Oftentimes, if the patent trolls are the legal owners of these patents, then it's really legally a matter for the court to decide whether or not they're infringing, and it's really a problem. I wanted to ask both you, Mr. Dewan, and you, Professor Feldman, what separates a so-called patent troll from a legitimate company asserting its patent? Can we really come up with a bright line here?
So I think the question to focus on is whether there are new products coming out of this. As there's been a lot of attention on patent trolling, and no one wants to be the bad guy, and everyone wants to draw a definition that says, I'm not a bad guy, that's over there. And you can parse these in many different ways, but it all comes back to, it seems to me, we grant patents in order to get new products out for society and strengthen the economy. And the question is, where are the new products in this activity? Is any of that coming out of here, or is this just a tax on current production? You have to pay it in order to go about your business.
What do you think, Mr. Dewan?
So I agree. You know, I think there's a very simple definition for what a patent troll is. A patent troll is somebody who uses patents to abuse the system to reduce social value for their own personal profit.
Okay, but that's not a legal standard.
I don't think that, I understand that it's not a legal standard. I think that when we look at what we want to do in terms of regulation, right, we shouldn't be focusing on, how are you making your money? We should really be focusing on, what is the behavior that you're taking advantage of, right? In this case, the behavior that they're taking advantage of in order to threaten people and detriment society is they're sending out letters that really don't provide information, that basically just tax companies that are actually producing. And on the flip side, they don't produce anything themselves.
Well, there's a lot of suggestions that different people have, both in front of the Judiciary Committee and this committee and in the Senate. So I would ask both of you and also the rest of the panel, if you have ideas for things we can do in statute to help prevent this kind of behavior, to set that bright line, that would be really helpful to us. And I yield back. Thank you, Mr. Chairman.
Thank you. Yield back. Now go to the gentleman from Virginia, Mr. Griffith, for 5 minutes.
Thank you, Mr. Chairman. Following up on that, Mr. Siegel, I was intrigued with some of your comments in regard to what Ms. DeGette was just talking about, some ideas. And I believe, if I remember your testimony correctly, what you indicated was that if you were going to send a letter of this nature, because you might have a legitimate claim, then make it a requirement that that claim be stated up front. Did I understand that correctly, and would you expand on that, please?
That is correct. If they actually had proof that they did proper due diligence to have a reasonable belief that we infringed, we would happily discuss the infringement contentions with them and try to come to a resolution if they were in good faith. It's very clear from the letters we've been getting that they do not have that good faith intention. It's spray and play. All the demand letters are all the same, just with a different company name.
And so all they say is we have reason to believe that you may have violated the terms of our patent and therefore pay up.
And then when we called them, LumenView, it was very clear they hadn't even been to our website, didn't really understand the functionality, didn't even understand their patent that well too. So it's very hard to deal with the situation when they are actually more concerned on the cost of defense as their main reason for exercising these demand letters, opposed to the merits of the infringement.
Right. Of course, it's not always easy to figure that out, and somebody may have a legitimate claim, even though their motives may not be great, they may actually have a legitimate claim. But it does seem to me that we ought to be able to work out some language, probably in the Judiciary Committee, but perhaps we can in this committee as well, figure out some language that ought to be included in that letter that would be a requirement that you notify the company prior to filing a lawsuit. I don't think you can say necessarily the first letter, but you could say that prior to filing a lawsuit on such a claim, you have to provide the defendant company with the follower, defendant individual, whichever it may be, with the following information, and then go A, B, C, D, E, to basically, to state a reasonably articulable theory of why you think you've been damaged.
Yes, and at a very minimum, the claims in the patent that they're actually inserting, there's usually lots of claims in a given patent, and in our case, they don't mention which claims, and so that has an undue amount of work and time and effort on our part to then have to research every claim. So at a minimum, they should disclose which claims, provide some evidence of due diligence, screenshots from your website, what evidence they have to believe that you infringe, and with that, we're okay with those. That shows they have a good intent to potentially resolve this issue. It's this type of behavior that we think needs to be stopped. And I think a lot of it's just because it's so easy to send a demand letter, there should be some minimum standards of what that should entail.
Well, I appreciate that very much. Mr. Richardson, you indicated that you all had gotten a letter for just linking a site. Was it the site that they were upset about, or the fact that you used linking technology? Because I'm surprised every member, if it's linking technology, I'm surprised every member of Congress hadn't gotten a letter. I'm linked stuff through my website every day.
Never know. Today's mail might not be here yet.
Yeah, well, that's a good point.
That is exactly what the claim was, and it was insertion of a hyperlink, URL into tweets, into a customer email, just to make it easier to, direct our customers who had opted in, who wanted this information, an easier path to get to it.
Wow. And then, of course, there's the safety factor, because not only are there more requirements in regard to service of food, as your industry does with White Castle and lots of other fast food chains out there, people want to know what all those ingredients are. It's not only the calorie intake, it's, what are you actually putting in there, because food allergies are on the rise. And you're saying that you got a letter on trying to do something like that too, that you had to put on the shelf because you just couldn't afford the price of litigation?
Yeah, very similar to that, because as we're looking at new menu board technologies to
Right.
make it easier to share that nutritional information or to change a price or change an offer, the claim there was that was a violation, actually because of how we were using the internet to send the information digitally. And we'd be okay if we wanted to put it on a jump drive and drive from Columbus to Louisville, but not to be able to use the internet to do that just didn't seem to make much sense to us. But that's one where they didn't even send us a letter. They went straight to litigation, as others have referenced.
Wow, that's incredible. I will tell you that that's of great concern, because particularly for the smaller chains or the mom and pops, they just don't have the ability to get that information out there if they can't put it on the internet, and that's a real problem that will affect their businesses. Mr. Chairman, I appreciate you doing this hearing. I appreciate all our witnesses being here. This is a subject area. I too am a lawyer, but I never represented corporations unless they were small mom and pops. I didn't do this kind of work, but I really appreciate this. It's been an eye-opening hearing, and thank you so much for doing it. I yield back.
Gentleman yields back. Now recognize Mr. Lawn for 5 minutes.
Mr. Chairman, thank you very much. And Mr. Cheng, I appreciated very much a point that you made in your written testimony about focusing on the abusive activity itself rather than the form of the party involved. The point that I'd like to make is your promotion of the term abusive patent asserter as opposed to the more commonly used terms of non-practicing entity and patent assertion entity, because national labs, universities fall into that category. And so I'm hopeful that as we talk about developing our legislation, that we're very careful to go after the bad actors and make a clearer differentiation between universities and the national labs, coming from a state that has 2 national labs and a district that has what I would describe as the strongest and best national lab in the country. But with that being said, Mr. Chang, to you and to all of the witnesses, I'd like your thoughts on that about as we target this area, what can we do in that specific arena, or are you seeing activity coming from any entities such as those that I've described?
Well, big picture, Congressman Lewin, you know, I think that reform efforts at some point have to take the economic incentive to engage in abusive patent litigation away, or they have to give the victims of this type of litigation some recourse. Presently, the system is very, very asymmetrically stacked, both substantively and procedurally, against parties that get demand letters and parties that get sued. It's very easy not just to crank out demand letters, but also to crank out lawsuits. You know, filing a lawsuit is actually not much more expensive, a form lawsuit, not much more expensive than sending out a demand letter. And in all sorts of different ways, you know, in the ways that, for example, a shell entity can be created to file lawsuits and issue demand letters with no recourse for the victims at all, even when they win, right? I mean, there are opportunities, I think, for Congress to take a look at what is being done by these abusive patent asserters. In my written testimony that you cited, my goal is to focus not on the form of the sinner, but on the sin itself. We love the sinners, or we could, but it's their actions and activities that actually are causing a lot of harm to society. It's causing companies and entrepreneurs not be able to start their companies, not be able to spend money on creating jobs and making products that your constituents use.
Very good. Anyone else? Mr. Siegel?
I agree that educational institutions are in this weird area where they're not practicing entities, but I believe their belief in creating this technology is to license it out so that it can become a product and help spur innovation and help consumers. When I've been lobbying on the Hill the last couple days, I've heard that the University of California school system has been against patent reform. And as a graduate of the University of California in Berkeley, not so happy with that. But I think they have a good faith in what they're doing with their patents, and I would be okay with them having an exclusion for being an educational institution.
Appreciate that, Mr. Siegel.
Sir, may I comment?
Professor? Dr.
Yes.
Ms. Feldman?
Thank you. The universities have a unique position as keepers of the academic flame and also recipients of taxpayer money. There's increasing pressure on universities to transfer their patents to those who would assert patents in licensing and litigation. The Association of University Technology Managers has just announced that it's going to rethink its policy of not transferring patents to non-practicing entities, and that can be troubling. So in any legislation you draft, you might want to be careful about how you craft it, because if you leave out universities and joint ventures, you may create a large loopholes for those who would simply purchase rights from, or join hands and hide behind universities for their activities.
Very important point. I appreciate that. Professor Feldman?
Well, we'd like to see some protections for end users. You know, again, our operators don't manufacture the technology. They just purchase it off a shelf and then install it at their property and operate it for the public. So some sort of protection that, you know, provides protection for the end user would be fantastic. You know, it's not just the hotelier that could be sued for a Wi-Fi infringer. It could be you or I for purchasing a Wi-Fi product and operating it out of our household. Allegedly, we'd be violating that same patent. So we'd like to see some sort of reform that involves protecting the end users, having us last in line for a lawsuit for technology we don't understand, we don't manufacture, we just merely purchase and use.
I appreciate that. As my time's running out, Mr. Chairman, I want to commend both the majority and minority staff for the witnesses that we have today, and would invite their input and recommendations to the committee that we could get to the FTC with the upcoming study in 2013. And I think it'd be great if the FTC would actually invite the witnesses to sit down and have serious conversations with them to include those in aspects of the study as well. So thanks again, Mr. Chairman, to you and to the staff, and Ranking Member DeGette.
Thank you. The gentleman's time has expired and he yields back. Speaking of the FTC, so let me follow up on that. I want to, so you know that they're going to be conducting a formal inquiry touching on many of the issues you've discussed today. Has any one of you had a chance to review the proposed scope of the FTC inquiry?
I have looked at it.
Yes, Ms. Feldman? Okay, can you talk about that?
I think it's an important step. We can't solve what we can't see, and much of this is shrouded in non-disclosure agreements. I applaud those who are here and willing to speak, because people have been afraid to share their experiences for fear that they will be targeted by those who propagate these lawsuits. The FTC action contemplates looking at 25 patent assertion entities. That's a start, but it's a small piece of the puzzle. My own view is it will probably take several types of steps. So there is low-hanging fruit that can be addressed now, and then there will probably be some longer-term efforts once we understand the problem better, once the FTC has finished its investigation.
Have any of you met with the FTC on this issue?
I've spoken to staff members.
You have done that. Let me ask this, although people are too, are there any specific issues you've encountered prior to litigation that you think the FTC should prioritize, or the areas you think are receiving less attention that they should, especially those who have been involved with litigation? Mr. Siegel, is there anything that you think they should prioritize?
What I was most surprised about prior to litigation was just how deceptive they are. It's very much corrupt behavior. They threatened criminal charges against us for calling them patent trolls at one point. So behavior like that, where it's very clear that just how corrupt and unfair it is, I think you'll see a lot of it out there. And it would be interesting for the FTC to investigate that. And I think specifically a demand letter registry would be interesting as well, because I don't think anyone knows the complete scope of how many demand letters are being out there, because there's no way to track it. And if you're given a patent, you're basically given a golden ticket, the right to have a monopoly, and with that responsibility comes the right to act in good faith. And I think it'd be reasonable to have them register all the demand letters they send because we're giving them that monopoly.
Thank you. Mr. Brago, do you have some comments on this in terms of what the FTC should look at?
Yeah, and again, I think, some sort of protection for end users here is really key. Some sort of regulation by the FTC would be helpful that prohibited this sort of predatory behavior on behalf of patent trolls prior to filing a lawsuit. Be that a registry, be that some sort of a system or mechanism in place that prevents them from filing just masses of lawsuits. This is a numbers game for my clients. These patent trolls will sue hundreds of individuals and corporations, all with one form letter, just swapping out the name of the company. So some sort of regulation that prohibits that type of behavior from occurring would be very beneficial to us. We'd see quite a bit fewer lawsuits filed, I think, in the state of Texas.
Mr. Richardson, could you talk about any comments you would want the FTC to pay attention to?
We would echo the sentiment that it needs to be focused on the end user. Registry is a great idea, but we think it's a two-step. It's real important to look at the demand letter as well and to get to clarity and understand that. In our instance, to echo that sentiment, one of the things we've had to deal with is using outside counsel, but our legal costs as a percentage of our legal costs has gone from 0.25% for patent-related issues to 20% in the most recent year. So it's real cost. And Congresswoman, you referenced abuse, and the victims of the abuse are our customers and our team members, and it's not just the companies, it's our neighborhoods that are suffering as a result of this.
Curious, what does it add to the cost of your products, all this?
At this point, the real cost is opportunity cost, because we're avoiding moving forward with the technology, because that's our only defense. So we haven't had the big lawsuit or had any big settlements, but it's holding us back. That's the big issue.
Then let me ask this. Are there other areas outside of technology that have been impacted by these recent patent assertions? Anybody?
So in the startup demand study, 70% of those who finance startups said that they had seen this in technology, but 30% said that they're seeing it in life sciences as well. We know anecdotally that we're also seeing it everywhere, mom and pop stores, restaurants, coffee shops, across the board. It started in technology, but it seems to have spread.
Thank you. Mr. Chang?
Yes, Mr. Chairman, we're a retailer, and it's all over. They've been targeting retailers for a couple of years already. They're hitting logistics companies. It's literally anybody with a business they think they can get money from. But if I could have your indulgence and just to echo and expand on what Mr. Bragel was saying earlier, in terms of protections for end users, I think some sort of regulation that could expand the doctrine of exhaustion to help at least end users at least have a defense up front to a patent infringement assertion, as long as they're licensing or purchasing technology or products in good faith from another party. That would be very, very helpful.
Thank you very much. I see my time's expired. I really wanted to ask Mr. Richardson if square burgers were patented, but
The 5 holes are.
5 holes. Thank you. Thank you. Ms. DeGette.
Thank you, Mr. Chairman. Just a couple of questions. Mr. Richardson, you talked about Congress doing something about the demand letters, and that's I think a good idea. Some people have suggested that the FTC should establish a demand letter database. I'm wondering what our witnesses think about that. We'll start with you, Ms. Feldman.
I think some type of a registry would be very important. Patent is supposed to be a notice system, and a lot of those in this assertion behavior claim that the way they're asserting their patents is something that's private to them. But what you claim as your territory is something that everybody should have notice of.
Yeah.
And that's it, and that's important. These non-disclosure agreements are very corrosive for getting information about what's happening.
Mr. Dwan, what do you think?
So I agree. I think that it's important that we have the sort of information about the demand letter economy, about what sort of assertion is going on. I think it helps out a lot of parties. It helps out the businesses that receive the demand letters because they're able to see, a lot of the facts that they may not be presented with immediately. It helps the related businesses in that they can see what sort of patents have been asserted, and they know what sort of technologies they should look at and what sort of technologies they should avoid if they have to avoid infringement. It helps researchers, obviously, because they'll be able to do better studies, and I think it helps lawmakers like you.
Well, it helps regulators too.
Because
if there's unfair trade practices going on, right?
I think that's the first step. I definitely applaud the FTC for taking on their 6B study of patent assertion. But I think an important point to realize is that for every one of these big patent assertion entities that we're talking about, there are dozens or hundreds of much smaller ones, the ones we've been talking about today, that would just fly under the radar. The FTC would never find out about them. Congress would never find out about them. The only people who would find out about them are the people who received the letter.
Well, unless you had a demand letter database.
Exactly.
Yeah.
And I think that's the importance of that. That's the importance of
Mr.
that.
Cheng, you're nodding your head, yes.
In complete agreement, and also I think one of the other benefits of a demand letter registry is simply to let victims know they're not alone. A lot of the people who get these letters, they don't know what to do, they don't know who to turn to. It's going to help defendants, or in some cases, organize a legitimate defense against sometimes truly craptastic patents.
Mr. Siegel, let me ask you, and the others as well, if there was a demand letter database and you knew about it, then I would assume if you got a demand letter, that would help you try to figure out
That would be an
what
absolute huge help. When I got my first demand letter, I went and searched for the docket to see who else they had sued, and I reached out to 20 people on LinkedIn. We formed a joint defense group. It took a lot of time and effort to email them all individually, see where they were in their course of litigation. If that was made available and easy, it would have saved me a lot of time. And ironically, when I reached out to them, their reply was, "That was so smart of you to try to pull us together. I didn't think of that," which I know it sounds funny, but it's actually what happens. Yeah. I've heard from the meetings I've had on the Hill that the USPTO or FTC doesn't want to have to deal with the administration or technology burden of hosting a registry. I would like to offer that Find the Best, we are a data company. We deal with data a lot, and we can easily do that, and we would be happy to work with the public sector and host that for them.
Well, there's some debate about whether the PTO is the office to do it or the FTC, and the FTC is more used to taking issues like this. Mr. Bragel, what do you think?
Well, like everyone else on the panel, I think that's a good first step. But from our standpoint, it's not just the demand letters we're dealing with. There's actual lawsuits that have been filed. And so, most of those were preceded by a demand letter, but either way, the lawsuit was going to be filed because it's relatively inexpensive to file a lawsuit and extract a $5,000 settlement from, my member at that point. In our case, it wasn't difficult to organize us. They're all members of mine. So I know who these folks are that have been sued. They all called my office, immediately upon receiving the lawsuit. But the question was, once they've been sued, they have to individually defend themselves. So we couldn't do some sort of joint mass defense like a reverse class action. And so, we were forced to inform clients that they should consider settlement. But again, it's always good to know who's after you, right? And it's good to know who's behaving in this sort of behavior. And there is so much in terms of hiding behind shell corporations and whatnot that this would lend some transparency to that. So we would support that.
Mr. Richardson, you're the one that started the conversations about the demand letter. So what do you think about this?
As a family-owned business, for us, it's about mutual gain through voluntary exchange. That's how, for the past 92 years, we built our business. And patent trolls don't use that business model. They use coercion. So anything, the registry, other things that can shed more light on it, we think turn the tables and start to, get us back to an even keel and bring more truth to the situation.
Thank you. Thank you. Thanks to all of you for coming. This is a good hearing.
Thank you, Mr. Griffith. You're recognized for 5 minutes for final questions.
Thank you, Mr. Chairman. I'd be interested in hearing from any of you in regard to, and I think it was the hotel folks that said, they were being sued for using Wi-Fi, and they bought it from a, Best Buy or other provider, from a manufacturer, but they, that they purchased it. The hotel purchases the Wi-Fi unit, installs it, and then they're the ones getting sued. And I'm wondering if anybody has looked at seeing if one of the manufacturers or the big retailers would be willing to support some of these defense lawsuits, either by warranty of their product or in some other way. And has anybody heard anything in that regard?
So some of the larger manufacturers have tried to step into court and defend these lawsuits, and they've been rebuffed. They're not allowed to because those who are bringing the demands are smart enough not to sue the big guys. They just sue the little guys, and so they can't get in there. So rules along those lines would be important.
So perhaps as we as a Congress, it may not be our committee, but as we as a Congress look at this, we may want to look at some standing issues and create some special standing for the manufacturer if they are the folks who put it into the Wi-Fi in the example that we're using.
I think the other issue
they would have the right to come in and defend themselves or defend their product in such a suit.
I think that's right, sir. And the key issue is to get all the interested parties in the courtroom or in whatever the bargaining room is. So one of the problems is you can't figure out who's behind these letters. So some type of disclosure of who has a beneficial interest in these companies, then you could figure out that perhaps you actually did buy something that comes with a license, or regulators could see what's happening behind the scenes. There's just no way to penetrate through all these shells and figure out where it's coming from.
And also, correct me if I'm wrong, and I know we've got a couple of attorneys on the panel, but if we bring all the parties to the table, wouldn't we be able to use collateral estoppel or res judicata and then future litigations and shut it down nationwide if we got one good lawsuit on the Wi-Fi situation? What do our lawyers have to say about that?
I think that's correct, and that's the reason that you don't see them going after the big manufacturers. They could just go after the company who makes the Wi-Fi routers, right? If they did that, they would get one settlement, that would be the end, and there would be no further lawsuits. Instead, they can go after as many people as they want by never touching the manufacturers. And this is really what creates the incentive for a lot of these abusive companies to go after end users rather than to go after the manufacturers. The fact that instead of having just one lawsuit that you fight and maybe you win, maybe you lose, you have an endless stream of revenue.
Right.
If it's not Wi-Fi today, it's our lock system tomorrow, we're afraid, or that treadmill in our fitness center. Where does this end? That's where we are with this. And if we settle one case, does that make us a target for additional patent trolls that may say we're an easy target?
And once they find that you're not an easy target, then do they go after the individual consumers who may have purchased the same product for their home? That's right. They may not be asking for the $5,000, but they might very well be asking for $150 or $200. And I can assure you, most households are not prepared to receive a letter of that nature. I have about a minute and a half left. Does anybody have something that we haven't touched on today that they would like to bring up? Yes, sir.
In touching on the subject of getting manufacturers to people upstream to stand behind their product, one of the unfortunate side effects of patent trolling is the fact that a lot of suppliers have actually stopped honoring their indemnification obligations. We've actually had to sue one of our technology platform providers because they, after being sued twice, after they honored the first indemnity obligation, they just decided it was too expensive, right, to keep stepping up. And there so even though we're not being, I've submitted this in my written testimony, even though we're not really being sued anymore, we're still in the game because we're still paying. We're still paying and our customers are still paying. And patent trolling is a toll on everybody.
I would like to stress the important role that this committee has to play. According to the figures in the White House report this summer, conservative estimates show that 90% of this activity never proceeds to the courthouse. And so the committee has an important role to play in establishing what are fair and reasonable business practices as opposed to deceptive practices in this particular area of commerce.
Thank you very much. I yield back, Mr. Chairman.
Thank you, and I want to thank everyone for being part of this hearing today, and also to note that you stepped forward and gave some valuable information, and those of you who are willing to come forward in this, I think also hopefully inspired many of the businesses not only to step forward when they have these concerns, to do the kind of things you have done to reach out and form some coalitions to fight this, but also shine some light on this for those who did not even know it was coming, and I hope that we'll continue this. I ask unanimous consent that written opening statements from the members be introduced in the record, and without objection, the documents will be entered in the record. So in conclusion, once again, I thank all the witnesses and all the members who attended today. I remind members they have 10 business days to submit further questions for the record, and I hope you'll be willing to respond to those letters. Thank you very much, and please respond promptly to them. With that, this hearing is adjourned.
Thank you.